around them. What if they want to be a chef? They go to culinary school, you know? And in your world, that's not college, but in somebody else's world, that is college. But it's all out. It's all out there.
Remember Brewster's Millions?
My youngest is going to be a chef, by the way. Go ahead.
No, I was going to say, remember Brewster's Millions?
Yeah, Brewster's Millions, right? Great movie.
Yeah.
That's just a movie, dude. It's not reality. Yeah, okay. Any other? Yeah.
So you have appointed a Mufti for your trust, let's just say.
Yeah.
And by the time you are dead, your Mufti is also dead.
Yeah. We get this question a lot. How you feeling? Yeah.
I'm just saying, so what will happen then?
There'll be more. I mean, your religion's been around for a long time. I think you're okay.
Can you have a backup Mufti or on the way?
We don't just name him. We say you select a Mufti, whoever it is, of any Islamic center. And then if there's a dispute with somebody in your family over it, they select a Mufti. It just has to have that qualification. Okay. That's the whole idea. Somebody learned, you know, educated in Islamic law. That's the key. It doesn't have to be Mufti.
So you can specify criteria. Whoever passes that criteria will be your assignee?
No, actually, I have the all. It means complete 6 calculation how to distribute as per the Quranic verses, ayat number 11 and 12. And we have practiced this 20 years in Dubai by the Islamic court.
Yeah.
So I can give you reply to your all this question, because this question will come up in your mind, having the property possession and distribution over here and Islamic value. So both I can reply. Let them finish first.
Yeah.
I'll give you a question, reply to your own question.
You can pick any Mufti you want. But to acquire that title, there's certain things that person had to have done and accomplished, right? You just
So the easy way was just to say a reputable Darul Ifta, fatwa department. I'm trying to.
So maybe you put it up on your shirt, it might
You
be.
think it's better this way? Yes. So since muftis are disposable or expendable, so you can appoint just say a reputable Darul Ifta. Right, and that would suffice then. So any reputable Darul Ifta, there definitely would be something existing, inshallah, to the end of time, and that will take care of your need, inshallah.
So the question, is that going to... Chris?
repeat the question.
Okay, I'll come up and ask the question, that'll make it easier.
Question is, does the Mufti get to override the state of Washington law?
Yeah. In a trust,
Yes.
yes.
Okay.
In a will, no. Yeah. And that's one of the things I'm really excited about that we put together over the past 2 months, is this dispute resolution mechanism. A trust is private. The terms of the trust, there's certain requirements it has to have, but beyond that, it's kind of a blank piece of paper. So what we've crafted is this. The other estate plans that I've done have an arbitration provision where, under the rules of United States arbitration as set forth in New York and stuff. Well, what I've done for you, along with Mufti Suhail, is we've crafted a dispute resolution unique to Islamic law. That's the cool thing about it. You don't get that with a will, but you do get it with the trust. With the trust that I created. Not any trust, but not the trust on the internet. Not there. Our thing, yeah, is there. Is there a question in the back? No? We good? Okay, yeah.
A question about taxes, state taxes or debt taxes
Yeah.
or other
Yeah.
questions. So you said when a home gets transferred to the heir, the strike price is that market price at that time.
Correct.
$700,000 at that
Correct.
time. Now, does that count against that $4 million at $700,000 before it?
Correct.
700.
Correct. It's the gross. So if it's worth 700 and you owe 695, it still counts as 700. Yeah. Okay. Do you want to take a? It seems like we're on a roll. If you want to take a break, we can take a break because I'm getting ready to talk about how trusts work. So it's up to you. I guess it's up to your call.
We should just continue.
We're going to continue. Okay.
How
Can
is the
I-
wealth tax? Is it based on where the business person dies?
Towards the end.
Yes.
Towards the end. Right at the end, inshallah, you can do it.
Yeah.
Can you repeat the question, please?
So he said on the tax, is it based on where you reside? And the answer is yes. And you know, sooner or later you're going to hate asking me questions. But here you go. Here's the answer. If you live in Washington, then we count your worldwide assets, but it's prorated. So let's say, and I'm going to use big numbers so that this applies to everybody. So let's say that your Washington assets are $1 million, and that you own other property in another state, and that's $100,000. We count the assets in the other state as well. So your gross estate is $1,100,000. However, it's only based on the percentage of the Washington is the tax. And since you're under the $2 million, you're okay. In Oregon, and I'm not going to ask for a show of hands, but I'm just going to give you a warning. If you own real estate in Oregon, you need to call me. Here's why. Oregon's limit is $1 million. Oregon counts your worldwide assets. Period. Ding. So here's how the law changed. Nike is based in Oregon. So what was happening was you'd have somebody in Washington or Texas or wherever, and they owned some shares of Nike, and they died. And then Oregon would say, hey, you own Nike stock, and that's in Oregon, and you owe us some money. And our limit's $1 million, and we count your worldwide assets. Which caused some problems, because, well, why would you buy Nike stock? If you had more than $1 million, why would you ever own Nike stock? You would buy Microsoft or something else cool, right? You'd own Amazon. Anything but Nike, because you write a check to Oregon. So they changed the law a little bit, but here's the kicker. What they said is, look, if you own personal property in Oregon, that doesn't count. But if you own real estate, then everything counts. So if you live in Washington and you own Nike stock and you die, you're good. Okay? But if you own any dirt of any kind in Oregon and you die and you have more than $1 million in assets, they count your worldwide assets. Whether you've actually gone to Oregon or not gone to Oregon, it counts. You owe a check. I figured out how to fix it. Here's how you fix it. LLCs are personal property, like Nike stock, right? So if you got some property in Oregon, what we do is we move the dirt into a Washington LLC. Your trust owns the Washington LLC. You die, or you're incompetent or whatever, it's in your trust. You avoid probate, and you do not own any real estate in Oregon. You own an LLC, personal property like Nike stock. Now that LLC might own some expensive real estate or inexpensive real estate, I don't care, but it owns the dirt. So we avoid Oregon tax. So I'm not asking for a show of hands, but if you have friends or family, or if it's you, dude, you gotta give me a call. Okay.
I have a follow-up question.
Yeah.
Are there any tax, say for states, like if Washington is taxing more, are there any other states that would tax less?
Each state can make their own estate probate tax. There are very few states that have it. Washington's one of them. Oregon is another. Idaho does not. Nevada does not. California does not. Arizona and Nevada, none. So what we do is, and I don't want to get too far afield, but when you have assets more than $2 million, as long as you're south of $4 million, we can manage things in the state of Washington and you're fine. Once you get north of $4 million, when you get between the $4 and $7 million range, $7 million is the sweet spot. What you do is when one spouse dies, then the other spouse should consider relocating to Nevada, because Nevada doesn't have any state income tax, and they also have the federal $5.35 million exemption. So by doing that, changing your residence, I can save you $565,000. So if you like money, it's a good way to go. But each state does it. It's just you happen to live in a state where we do. Yeah. Okay. Any questions on this one? No?
Question, so you talked about the state estate tax. Is there a federal too? Or?
Yeah. The federal level is $5.35 million per person. So if you live in Nevada, you can shelter $10.6 million, husband and wife. But because you live in Washington, it's $2 million, use it or lose it. So, and the reality is that it's an unlimited transfer among spouses. So, I'll give you an example. Bill Gates dies. He can leave $2 million to whoever he wants in Washington State, use it or lose it exemption. The other billions of dollars could go to Melinda, his wife, or whoever he wanted. You avoid tax. All the transfers to the spouse is unlimited. So he can't leave it to, there's certain charitable deductions and things like that. But let's say he left it all to his spouse. But now spouse has a problem. Spouse can only give away $2 million. So if you do things correctly the right way, upon the death of the first spouse, we're usually good. But that's when we got to start doing something else for the surviving spouse. Okay. Any question?
So, do the trustees need to be over here in the United States, or can they be in India?
They can be anywhere you want. That's another cool thing about it. Yeah, I have clients all over the world. London, Dubai, some in Pakistan. And that's one, there's a lot of great things about the internet, but that's one of the great things about the internet, in email and video conferencing and Skype and all those different things. It makes it a lot easier to administer a trust located in Washington with somebody who's in a different country or even a different state. I don't care if you're 50 miles from here or 5,000 miles from here. Yeah. Any question? Yeah?
Can the trustee misuse the trust before overrides trust is incapacitated? Because you mentioned that's effective immediately.
Right.
So can the trustee misuse it before it should be used?
The successor trustee, or because you're the trustee. If you create a trust, you're the trustee. If you and your wife create a trust, you're the trustee. The successor trustee is only if you become incompetent, then it goes to or you die. So, and I can tell you, the
beneficiary, the person who will be managing the wealth.
Yeah. So it's a little bit of a checks and balances when it comes to that. I can tell you it rarely happens. I've been doing this 25 years. I had it one time. And it gets caught pretty quickly because they have, when the successor trustee kicks in, they have to provide an accounting to all the heirs, all the beneficiaries. And believe it or not, when you're named as a beneficiary, for some reason you start caring a lot about money. So they ask for the accounting, and it's pretty easy to catch. Bad things can happen in anything, with the executor of a will through a probate, bad things can happen. The successor trustee of a trust, sure. But here's the deal. Pick somebody you trust. You pick. Don't let the state of Washington pick for you or some other creditor or whatever. You pick. Pick somebody you trust.
Like what if someone picks his wife and then a divorce happens?
Well, then it's the trust is not nullified, but the power, and it says that specifically in the powers of attorney as well, then terminates upon dissolution. For both, goes both ways.
A question following up on that trustee being another country.
Living somewhere else, yeah.
Yeah, but does that person has to come into Washington to execute that trust, or
No.
physical presence, is that necessary?
No. I just did one, trustees in Spain. So the trust sold real estate here. We FedExed the documents to Spain, Madrid. They signed them, they notarized them according to Spanish law, sent it back here, recorded it.
Who did the things on their behalf here?
Attorney.
Who did the attorney did the stuff on their behalf? Like, did they authorize the attorney?
The successor trustee hired me.
From overseas?
Yes.
Okay.
From overseas.
So the government will notify them overseas initially.
No, the government doesn't notify them. The government has nothing to do with it.
So you mentioned after the person dies, they have to file his will. So how will they get to know they are overseas?
Oh, that's if you open a probate. If you don't do a trust, then yeah.
Oh, okay.
If you don't do a trust, then sure. Then that makes it more difficult on multiple levels.
Gotcha.
Because when you have an executor who's not residing in Washington, what they do is they appoint a local agent, which is typically me, but we can still get to the same steps. But that's through a probate. You got to hire a
probate
lawyer.
is more like an inheritance, but a trust is more like a company. You're sharing with company.
Yeah, that's the concept. I would not describe it that way because that's not exactly accurate, but that's the concept. It's its own separate entity. It owns bank account, and that's actually where we're going. Okay. You want to keep going? You want to try? You want to say something or no? No? Shocking. Yes, sir.
In the will, like we are considering the entire list of property and assets, or each individual property and assets has different will. What I mean
One will.
One will for entire thing.
Yeah, that you can have as many trusts as you want, just like you can have as many businesses as you want or companies as you want, to use your analogy, but you can only have one will.
So I just list all items?
No, you don't list anything. Well, you can, sure, but it's not required. That's the difference between making a trust and a will. With a will, you just have to make a will and say, I leave, percentages this way or property to somebody, but you don't have to transfer anything into it. With a trust, same concept, but you've actually got to move the title into the box. And that's where we're going next. But you only have one will. That's it. Yes, sir.
Suppose I have some jewelry in my locker. Okay.
Where's your locker?
Yeah. In that locker. So in that case, how the scenario works like? Do I need to declare my jewelry in the will, or how is it?
No. Well,
Chris, can you repeat the question, please?
yeah, if he has some jewelry in a locker, and a lot of people have that kind of stuff, right? I mean, they've got important items that they don't want the world to know about, and it happens to be kept someplace, and that's fine. What we do in the trust is I actually give you, we keep talking about it, but seriously, buy a longer cord.
Let's see if we can pull it out.
No, it's funner this way. So this is like an estate plan that I do for you. In here, there's a transfer of personal property, and you don't have to specifically say it. It says jewelry, furniture, works of art, gold bullion, artifacts, whatever. A blanket statement that everything is in the trust. You don't have to specifically identify it. However, on the next page, you can leave specific items to specific people, and you can change your mind as often as you like. So you don't have to, because people like the idea of privacy. So you fill that out in private. I don't need to know about it. The government doesn't need to know about it. You and your successor trustees are the only ones who know. That's a cool thing.
So to open up a trust, you need to be in the same state? Can I open up a trust in Arizona, for example?
Yes, I'm licensed in Arizona as well.
Okay.
Yeah, I can do them for Washington, Oregon, Arizona, and Idaho.
Sure. So I live in California, I can open up a trust in Washington, you're saying?
Yeah.
Okay.
Yeah, it'd be a Washington trust. Or you could hire a California lawyer and do a California trust. You can do both. But if you own real estate, do one or the other. So like a Washington trust can own California assets. Vice versa. You could have a California trust own Washington assets. Right?
Is there a state that's best for opening up a trust?
Washington. No, actually we are. I say that kind of joking. But we are, because we have the highest level of requirements for a trust to qualify. Okay. So the trusts that I draft, the trusts that are properly drafted in Washington, are valid in all 50 states. Okay. That's not necessarily true of a different state where the standards are different, like maybe Louisiana or something. But we have the highest standard.
Just a follow-up question on that. If I move to another state, do I continue with the same trust, or
Yes.
do I have to re-register it in the new state?
This is good. Yep.
Christopher, can you repeat questions?
Yeah, he said if he does a Washington trust and he moves to another state, does he have to do a trust in that other state? And the answer is no. You're good. And one of the other things about a trust is they don't, and this might going to offend some people, I'm sorry in advance. It doesn't expire just because we say it expires, right? So when you make a trust, it's good from now on. It doesn't just someday become outdated and unsupported by Microsoft just because they choose not to support it anymore. Sorry.
You're not getting any more business credit.
I know. we're friends though, we're talking honestly, I'm just saying. But the trust, it's good from now on. If you want to change it, you can change it. What a lot of people do, though, is if they move to a different state, and it's been a while, what they might do is they might update their powers of attorney or their healthcare directive for that particular state. So like the healthcare directives and stuff for Washington are different from Oregon, they're different from Idaho, they're different from Arizona. The trusts are pretty similar, but you might want to update something else. Like Washington, for example, and we're going to talk about it in a minute. January 1st, we changed all of our power of attorney stuff. So it's different than it was in December. And ours are different from Oregon, Idaho, and Arizona. So frequently people will update and change that type of thing, but leave the trust alone. I'm going to start in the back and I'll work for it. Yeah?
Can you have a will and a trust?
Yes, that's exactly what we do. But the architecture of it, and we're going to get to this, the will is there as a safety net in case you goof up. Then we can go probate that one asset you forgot to put in there. We're heading that way.
All right, one more question. If you have property in different countries, should you have a will or something that specifies what you want in those countries as well?
Okay. You can only have one will. So we've addressed that. So we can only have one will. What I say is you should check. So let's say you did a Washington trust with me and all that, and we did it. It can own foreign bank accounts. It can also own foreign real estate. What you should do is take your new super cool, trust estate plan to a lawyer in that other country and say, is this good enough? And if they're based on English law, you're probably fine. So I can't speak to that because I sincerely don't know. But the roots of what we do in Washington and in the United States is English rooted. And so what I've seen, I know it's good in England. I know it's good in Australia. I know it's good in India. But beyond that, I don't know because I haven't had any experience with a personal review. We had two people. There's one right behind me.
So if I have a trust, do I still need to create a will?
Yes. Yeah, it's a tool in your tool shed because stuff happens. And I'll explain. You need to have a trust, a will, a financial power of attorney, a healthcare power of attorney, a HIPAA healthcare release, a designation of guardianship for you, a designation of guardianship for your minor kids. I think you need all of those things because all of those tools address different issues in your life that you're going to use at some point.
If your trust is attested by the Indian consulate here, this trust will be applicable legally in India.
Right.
And same thing, if you have a property in England, if you have attested your trust by the British consulate here, it will be applicable legally in England.
There you go. International lawyer. There you go. Total bonus. Didn't pay for it, just got it. Okay. Oh, I'm sorry.
Yeah, just a quick question. So you mentioned about the assets in different states, and if I have an asset in different state, I need to have a trust from that state as well.
No. I said you need to have a trust that owns title to the real estate in the other state to avoid probate in that state.
Okay.
So if you have a Washington trust and you own...
That suffices.
That's good. But if you own real estate in California, you want it owned by the Washington Trust. If you own property in Nevada, you want it owned by the Washington Trust. In Idaho, Montana, wherever, you want it owned by the Washington Trust. That way you avoid probate in those states.
So for example, a bank account is a trust, is an asset.
Is an asset.
And it's owned by a bank in a different state, right?
Yes.
So if I open the trust in this state, that's sufficient, right?
As long as you title that bank account in this trust.
So
not in your name.
right. So if anything happens after I create the trust, like open new accounts, getting new property in the future, whether it is in this state or overseas, I need to keep updating the trust on
Correct.
that, right?
Not changing the terms of the trust,
Updating,
adding stuff to the
stuff
trust.
to the trust.
Yeah, you can, and that's exactly where we're going. That's the next slide coming up. Yes, sir.
Actually, this relates to this. So, and also the law. So you mentioned like in January something happened. So I guess the assumption is when you sign a trust or create a trust, then it locks in the whatever the applicable law at that time, right?
Correct.
So, I mean, the trust could be used 20 years from now, law could be different, but
Correct.
it's, the law will be used that when you sign it.
Yeah.
But what about, like he mentioned that you're adding or like you're doing some amendment 10 years from now,
Yeah.
then are you then falling under the law applicable at that time, or is it still
You
the
keep the original trust date.
original trust date?
Yeah, it's called a restated trust, and if any, what we're talking about, if any of you already have a trust or estate plan, what we would do is we would update it, revise it according to what we're doing now. It's just, we keep the original trust date. So if you did it in 2001 or 1994 or 1950, whatever, we just keep that original date. We give, because when you amend a trust, you can amend one word, you know, but you can also amend all the words. So what we do is we amend all the words and we give it the new 2017 language. Yes, sir?
If you have several different properties, does it make sense to have each one in an LLC, separate LLC?
Different question, and I have a different opinion on it. It's management of risk. So if you have single-family homes, and this is my personal opinion, if you have single-family homes, I say it's okay to have it all in one LLC because the real risk is not that great. Now, if you are buying real estate, rehabbing real estate, and then selling that real estate to make money, I would do each project in a separate LLC to keep your risk segregated from your main assets. If you had a multi-family home, and by multifamily I mean more than 5 people. So if you're at 80 units or 16 units or 120 units or whatever, I would have that in a separate LLC because multifamily, just having that many people in that small of an area creates a unique set of problems and unique sets of risks. So in that situation, I would have that in a different LLC. But if you had single family, freestanding homes, I say put them all in one and just buy insurance. It's a cheaper, easier way to go. But that's only my opinion. Your risk level might vary. You know, I have some people who have 8 rental homes and they're all in 8 different LLCs because that's what they want and that's good for you. But that's not my personal opinion.
All right, let's do this. Since we're in a break, the plan is to break at 4 for snacks. Could we do one more segment before we break?
I would love to do one more segment.
Let's move on and we can take questions later.
Okay, here we go. Well, and this is perfect. So here's the so the disadvantage. So all good, one bad right here. There you go. It requires you to transfer assets into the trust. So you got to create the trust and then you got to move stuff into the box. It just doesn't happen automatically. You got to move the bank, you got to title the bank account in the trust. You got to execute a deed from your name to you as trustee of the trust. You got to change the ownership of your stock account to the trust. But you have to actually do something to move the assets into the trust. Okay, so here's the next segment. Actually, you know what? I'm going to do these out. We've already done this. I'm going to come back to this because we're going to take a break. So I'm going to do this. I'm going to tell you how it works. Might as well give you the solution before you go have snacks. Here's how we work. Okay? We've got you. We have Islamic law. We've got your parents, if they're alive. You've got a spouse, if you're married. You've got children. You've got siblings, brothers and sisters. Okay? We have title to assets, and now we know that everything has title, right? So we have bank accounts, what we've been talking about. Personal property, you know, stuff in a locker to be disclosed later, right? Cars, that says cars. There's a bracket there that says cars. And real estate, which we've been talking about. So this is you. This is you, and this is stuff you got. So here's how it works. You create a box, an entity, separate from yourself. It's governed by a trust agreement. And that trust agreement identifies the terms of how these assets will be managed. If I'm alive and competent, what do we do? If I'm alive and incompetent, what do we do? If I'm married and I die, what do we do? If we both die, what do we do? Okay? If we have a dispute, what do we do? That's what the trust agreement's all about. So you are the trustee. That's like the president of the corporation. You are the person that manages the assets. Separate property remains separate property. So, if you are married and you create a trust together and husband moves an asset into the trust, it's still separate property in the event of divorce. If husband moves property out of the trust, it's still a separate property. Same's true. If wife moves property into the trust, she can move assets out. It retains its character. The trust specifically says that separate property remains separate property. You pick a successor trustee and a backup trustee. So if something were to happen to you where you weren't able to manage your assets anymore, you pick somebody, hopefully that you trust, to manage the assets for the benefit of your beneficiaries. And you might be the beneficiary if you're alive and incompetent. They manage the assets for your benefit, or your spouse, or your children, or your parents, or your brothers and sisters. You designate your beneficiaries according to Islamic law. So it's viewed as your last act on earth, so you want to make sure it complies with Islamic law. So you can designate, the state of Washington doesn't care if you give 100% one way or 100% another way. The state of Washington doesn't care if you give 1/6 to your parents if they're alive or not. The state of Washington doesn't care if you give twice as much to your eldest son or not. The state of Washington doesn't care, but you care. So in the trust agreement, you can designate your beneficiaries, and in the unique opportunity you have is you have Mufti Suhail, who I've learned a lot in the past few months from about the gifting requirements. Mohammed, Sheikh, and I've known Sheikh for 20 years. Wonderful person, wonderful family. We tried to do his estate plan many years ago, and we worked on it for 9 months trying to get it right. And we came close. We came close. We wanted to get it right, but we didn't have the guidance of Mufti Suhail. So thanks to him, he took a look at it. We've been able to make revisions so that now Sheikh wanted to do the right thing. We tried to do the right thing back then. We came close, but not quite. But now we got it there. Well, we're almost there. We haven't signed it for the final one yet, but we're going to get there. Okay? So that's the goal for everyone. And you move title into your assets, title of personal property and all that. So you move your bank account, you move your personal property, you move your cars, you move your real estate. Whoop. Come on. You move it into the trust. And then you manage your own assets, and then your beneficiaries are whoever you designate. Okay, everybody get it? Okay, I'm going to start in the back and I'll come forward to you. Yes, sir.
If the car is sold, does it automatically get out of the trust?
Yeah, so Microsoft can own cars, boats, planes, bank accounts, real estate. If they're going to sell real estate, Microsoft sells it. If they're going to buy real estate, Microsoft buys it, not Bill Gates. So the assets change over time. So if you buy a house, the trust buys it. If you buy it in your own name, well, then you need to transfer it into the trust. If you have a car and it's in the trust sells it. If you buy a new car, the trust buys it. You're the trustee of the trust.
So yeah, you mentioned that separate property remains separate property, right?
Right.
So, but then you designate your beneficiaries. So then,
yeah.
What about community property? So what if you designate your beneficiaries in a way that doesn't maintain community property?
Both spouses sign the trust. Both spouses agree what's going to happen. Both spouses agree what happens upon the death of the first spouse. Both spouses agree what happens upon the death of the second spouse. It totally eliminates that issue. That's the cool thing about it. You figure it out now, not later.
What was the question, please?
Oh, if it's community property. If it's community property, well, husband owns 50%, wife owns 50%. But when you're husband and wife and you sign and you do the estate plan, both husband and wife sign the estate planning documents. The husband has a will, the wife has a will. The husband has power of attorney, the wife has a power of attorney. Healthcare directive, each. The trust, both sign, one trust. Now, you can do a separate property trust, and we do that sometimes.
We
In
can
fact,
make two trusts, one for wife, one for husband.
you can do that. That's where I'm going.
This is the Islamic trust. I will give you the one format of Islamic trust. I'll send you.
Whose show is this, man?
And then you check with the state how much it will be conflicting with the law.
Yeah, so it's flexible. So if husband and wife agree on all this stuff, you can do one trust and both sign it. Or if you don't agree, husband can do a trust, wife can do a trust, separate property, and designate. So it's flexible. Me personally, I have three trusts. So I'm remarried, I'm on my second marriage. She had a house and one child. I had 2 houses and 2 children. So she created a trust. Her house is in that trust. Her son's the only beneficiary of that trust. I have a separate trust where it's one trust, 2 kids, 2 houses. And then we have a third trust together where it's split equally. So that's my particular situation. It doesn't have to be your situation, but it's flexible. So sometimes the spouse wants to participate and sometimes they don't. We can't make them do it. But if you do, you can accomplish it either way. Yes, sir.
So, one second. They can't hear the questions, so
Oh.
unless you repeat it, they wouldn't know what you're talking about.
I apologize, ladies. The question was, can you do a separate property trust? Can you do a trust for the wife and yet a separate property trust for the husband? And the answer is yes, you can. If both spouses agree on the distribution of assets upon the death of the first spouse and the death of the second spouse, then you can do one trust and both parties sign it. If you can't necessarily agree on that distribution, then each person has the ability to create their own estate plan. They can create their own trust, put their separate property into it, and then we can have, and that's more common. I do far more blended family estate planning than I do traditional married family. It's just, the way it is right now. So having trust in the estate planning, it allows the flexibility for you to go either way. This guy's been waiting for a while.
So I like the example you gave about Microsoft. So this gives me the impression that I no longer own anything. It's the trust which owns everything. So,
correct.
Right?
Correct.
So now my paycheck goes into the trust directly. How does that impact my taxes? And
Exactly.
do I need to, for example, convert it is it the same, right?
Same.
So
Yeah.
simple tax filing every year, it's not like a trust owning or...
No. So, I know you guys want to take a break. We're going to take a break here in a second, but this is a great question. This is a revocable living trust.
Repeat.
Repeat the question.
Sorry.
I know why you asked, but I don't know the exact answers. The exact question. The question is, the trust is separate, so you transfer title of assets into the trust so that you personally no longer own anything, and that's true. Now you get a paycheck from your employer. You take that check, you deposit into a bank account that is owned by the trust. The question then becomes, okay, do I have to do anything separate regarding my taxes? And the answer is no, because the estate plan that I prepared is called a passive pass-through taxable entity. So it all flows through to you personally. So your tax returns look exactly the same. The tax identification number for the trust is your Social Security number. Prior to 1996, we did not have limited liability companies in Washington. So when we had multifamily apartment buildings and things like that, we would create a family trust. We would move the property into the family trust. It would get its own separate tax ID number. It would get its own separate bank account. It would file its own separate tax return. You can do it that way. After 1996 in Washington, and frankly in all the states, you could do it that way. We just don't anymore. Now we form an LLC. Put the stuff in there, and then the trust owns the membership interest in the LLC. But you can do the estate plan. You can get its own separate tax ID number, but there's no reason for it.
Which one is more beneficial for tax purposes? Is it?
None. No benefit.
A person died before paying tax. Then the tax due will be payable by the heirs?
No.
No.
It's payable by the trust, the assets of the trust. The heirs never pay
Yeah.
tax.
Same Islam though, yeah.
The heirs never have to pay debts. It's the estate. The estate pays the debts, the estate pays the tax.
Yes.
Somebody leaves you money, whatever you get, that's yours. Give me a call, you know. But you don't have to pay income tax on that. Yes, sir.
So are there any restrictions on the type of assets you can move to the trust? For example, does the home has to be paid off? Can it
No.
have a mortgage?
It can have a mortgage.
Yeah.
Title is one thing, liens are something different. So a lot of times the home has a mortgage on it, or the car has. Then what we do, in cars it's not that big a deal, but real estate, we do it all the time. We move it in the trust. And the reason is because you can undo it at any time. So, and 25 years have never had to come up. If a lender ever said, oh wait, it's owned by your trust, so you know the mortgage is due, all you do is do a deed out of the trust back into your own name, and that's why it never comes up. If it became an issue, it's a really easy fix, but I've never had it become an issue.
If you have personal debts, and you mentioned in probate that all the debts needs to be paid first before any of the beneficiaries get anything.
Yeah.
In the case of trust, how personal debts work?
The assets of the trust pay for them. So they follow through. And that's one, I was saving it for the next segment of it, about another benefit for the
You can
trust.
answer later, that's fine.
Yeah. Any other questions?
Yeah, so I know the state is more interested in collecting the debts, just the question was there, but what if you are interested in getting money from people for example, tax refund after you die, so who's going to be in charge of getting that?
Your successor trustee has authority to do that.
Will have the power of attorney to do that, okay.
Yeah. Yeah. Wait, what?
So if you are having multiple trusts, so the property cannot be in both the trusts, right? It has to be only in one trust, one single point of trust.
I missed part of
So
that.
if you have two trusts which you created, and
You have two trusts?
and the property can be in either one of the trusts. It cannot be in both the.
Yes, it can. It can be both. And so the question is, you know, if you do two separate trusts, husband does a trust, wife does a trust, can the property be in both trusts? And the answer is,
But his question is himself making two trusts.
you're making two trusts, right?
Yeah.
Yeah. So you can transfer your ownership interest, whatever that may be, in whatever assets they are, into the trust. So if there's a piece of property and you own 25%, you would transfer your 25% into your trust, and whoever owns the other 75 continues to own the 75. If you own 50%, your 50% is owned. Oh wait, this guy's been waiting. I'll come back to you. Go ahead.
You mentioned there are many states that don't have estate tax.
Correct.
Then why wouldn't I create a trust in one of the states that doesn't have an estate tax?
Because it's not where your trust is located, it's where you die. Yeah, so that's what we have is we have a situation now, and I'll come back to you, where let's say we're north of the $4 million range. What happens is husband dies, because we always die first, and then wife or beneficiaries are sitting on a bunch of money that's in excess of $2 million. They then relocate to a state that does not have state tax. So you go to California, or you go to Nevada, or you go to Arizona, and most people pick Nevada because it doesn't have state income tax. California has state income tax, and Arizona has state income tax. That's why you pick Nevada.
Just moving is good enough, or you have to create a trust in that state and move over to
No, your trust stays the same. It's your gross assets count for the estate tax. It's not where your trust is located, it's where you die.
So clarification, when you say where you die, what you mean is where you die, where you have the residency.
Correct.
You can't be the resident of Washington, die in Panama, then you mean that the trust is going to fall to Panama.
Correct.
So yes, it's the residency is what's important, not where you die.
Correct.
Two questions. Number one, what happens to the trust that both husband and wife have signed in the case of the divorce?
That is terminated as to both.
So the trust is terminated?
No, the gifting is terminated as to both. So the question is, when you have a trust and it's a husband and wife, and they both sign to one trust, and it's true if you made separate trusts, same result occurs. and then you get divorced, then the gifting to your ex-spouse is then terminated. And that's true if husband made a trust and named wife as a beneficiary, or wife made a trust and named a husband as a beneficiary, it's the same result.
But what's the status of the trust itself? The trust
It exists, just the ex-spouse does not receive a gift. So if, for example, you had a trust, and it doesn't matter, we had $1,000 in there in the trust, and I say 100% goes to my wife, and then if I were to get divorced, then that $1,000 gift goes away and it goes to the next level. Falls into what's called the residue, the remainder of the trust assets. The ex-spouse doesn't get anything. Now, after you are divorced, you can make a new will or a new trust and say, yeah, this is my ex-spouse. I choose to leave them some property, which I have happened. I mean, you know, that's the nice thing about estate planning and trust is it's flexible. I've had, the record for me personally is 5, where somebody has married and divorced the same person 5 times. You think you're conflicted, man. Yeah, 5. Okay.
So, just a point to what this gentleman said. So first of all, nobody knows where he or she is going to die. That's one thing, right?
Yep.
So what if you were to open like 50 trusts in every single state? Right? I mean, in that case...
I want to know that person.
Is that even a possibility, though? Just
Sure you could. I mean, you know, I'm a little different because I do it for a living. I have 3. I don't know, I have not done an estate plan for somebody, and I have people north of $80 million that have 1 trust. Some people have 3, but I've never seen more than 3 because there's no really need for more than that.
I think there's a confusion about the statement when you die.
Yeah.
Clarify the residency in your words, not in my words, so people understand what
Can you clarify that?
Yeah, it's where you're a legal resident of when you pass away. And that's kind of what I was getting into, and we're getting a little far afield, but let's say you had $7 million, what you do, and husband dies, you use the Washington State, use it or lose it exemption of $2 million, and now the beneficiaries have $5 million, and if the beneficiary, if the spouse, I'll make it easy, the spouse remains a resident of Washington and dies, the spouse could only leave then $2 million, and the $3 million excess would be subject to tax. So what people do is they change their residency to classically Nevada, sometimes California. You get a driver's license, you buy a condo down there or whatever for 100 grand or 80 grand, and you save $565,000. So that's what. Now, can you still hang out in Washington? Sure, come visit, it's a great place. But file your tax returns, Nevada. Federal tax, Nevada. Right?
What is the time duration for that? How long do I have to move there?
Before you die.
It depends. What if I die and the family were to do this? How long do they have?
No, you have to establish residency at the next place. So,
Alright, let's take one more question.
Classically it's 90 days.
Hassan's hand is up there right at the back. Hassan Hatem. And just a warning, that's an accountant.
Next question, please.
The trust is an LLC?
No.
Or it's under an LLC?
No. It's like an LLC. It's a separate entity. So I just use that as a comparison because people understand. So people understand that Microsoft and Bill Gates are not the same thing. It's its own separate entity. So a trust is its own separate entity. It has its own title to assets, its own bank accounts. It can file its own tax returns if you choose to do that. It's separate from you. And that's the reason why a trust avoids probate. Whatever assets are titled in the trust never dies, so there's no need to transfer title to somebody else. If you die, if you own title, then we have to do probate of assets that you own title to transfer them to somebody else.
But the taxation of that is treated like a single member LLC, where it's a pass-through entity.
Correct. Yes, sir. But you can also choose to tax an LLC as a subchapter S, or a C corporation, or a partnership. Yeah, so it depends.
Break.
But you get it. You is exactly. It's a separate entity, and you can do a lot of different things with it. Classically, it's a passive pass-through entity.